Good day, aficionados. It is September 24th, a Saturday. So what does that mean? It means that, yes, all in one convenient location are the top stories throughout the week. Thanks for watching. We'll see you next time. Next on the docket, a bizarre case in Georgia. A police incident report has shed a little bit more light on the mysterious death of a Georgia mother found deceased last week in Clarksville, Georgia. So on September 10th, 59-year-old Debbie Collier sent her daughter $2,385 using Venmo and included a message that read, "They are not going to let me go. Love you." That's according to the police report. After receiving the message, Collier's daughter tried to call her mother but could not get in touch with her. The worried daughter then contacted the police to report her mother was missing. Investigators determined that Collier left her house with only her driver's license and a debit card. Last Sunday, police tracked a rental vehicle Collier had been using to a wooded area 60 miles away from the family Athens, Georgia home. Police searched the vehicle and the vicinity around where the car was and found her body in a nearby ravine. As investigators descended on the scene, they were joined by multiple family members of Collier, including her husband. He told police that he last saw his wife at about 9 p.m. on Friday, September 9th, as he was going to bed. The husband went to work on Saturday morning and told investigators that his wife's vehicle was still in the driveway at that time. According to reports, Collier's husband reportedly said she was sleeping in a different bedroom the night before she disappeared due to his snoring. According to the sheriff's office incident report, Collier's vehicle was found unlocked and unoccupied and parked on the side of the road on Georgia Route 15, which is north of Clarksville. A red bag with what appeared to be the remains of a fire was located near Collier's body. Now, police say Collier had been partially burned and stripped naked. She was found grasping a small tree, according to the police report. So far, no arrests have been made. Bizarre case indeed. We'll see how that continues to develop. The judge in the Nikolas Cruz trial, okay, should we really say sentencing phase? He pled guilty to killing everybody down there at the high school that he was attending. And there was kind of a blow up last week. I don't know. Do we have that video handy, Frank? I can't remember if we got that video. Take a listen to this judge. She goes a little over the top, but go ahead and roll the tape.
Your Honor?
Yes.
At this time, the defense rests, other than putting in our records.
We're not playing chess. I mean, will you please take the jury back in? Thank you. All right, go ahead and put in your records.
2B, Nikolas Cruz Henderson, episode 1 record.
Let me just stop. State, are you going to have anything ready for today?
No.
We're
Last told us
accepting,
there was 80 witnesses.
we're waiting for 40 more witnesses.
I just want to say this is the most uncalled for, unprofessional way to try a case. You all knew about this, and even if you didn't make your decision till this morning, to have 22 people plus all of this staff and every attorney march into court, be waiting as if it's some kind of game. Now I have to send them home. The state's not ready. They're not going to have a witness ready. We have another day wasted. I honestly, I have never experienced a level of unprofessionalism in my career. It's unbelievable.
So, Judge, if we had any pretrial matters, you asked us to be here at 9:15. We were here at 9:15 to discuss pretrial matters. I have been practicing in this county for 22 years.
You know what? I don't want to hear it. I don't want to hear
Well,
it.
Judge, you're insulting me on the record in front of my client, and I believe that I should be able to
Okay,
defend
you
myself.
can do that later. You can make your record later, but you've been insulting me the entire trial. So, blatantly, taking your headphones off, arguing with me, storming out, coming late intentionally if you don't like my rulings. So, quite frankly, this has been long overdue. So please be seated. You can receive the evidence. I will receive the evidence. And then you can put whatever you want on the record at the end.
So the judge kind of lost her stuff. Now, I've seen a heck of a lot worse. It's not that big a deal. Frankly, the judge jousting a little bit with the defense attorney, and I'm going to have to side with the defense attorney in this case. Okay, everybody puts on their witness list everybody they think they're going to call. For whatever reason, the defense said, you know what, we're not going to call any witnesses. Now, as a matter of professional courtesy, could you have said, yes, we're going to rest? Okay. What's the big problem, Judge? Normally these type of situations come up when the prosecutors run out of witnesses, or you seat the jury and the judge says, call your first witness, Mr. or Miss Prosecutor. And everybody's sitting there twiddling their thumbs. And the prosecutor's like, oh, we didn't think we were going to sit a jury this fast. We don't have a witness to start. And then you just sit there and like, okay, we'll start again tomorrow. So normally it's the prosecution that gets scolded for doing something like that. I get it. It's an inconvenience to the jury. That's really what the judges are more concerned about than anything. Let's face it. They're there all day. What does it matter whether they're hearing witnesses or not? They're still going to get their paycheck, right? It's the jurors who aren't getting paid for this, other than maybe their $5 a day or $50 a day that they get, depending on the jurisdiction they're in. It's an inconvenience to them, but hey, if we're not going to start for another 2 weeks, why does it take the prosecution almost 2 weeks to get their witnesses together? And the prosecution has to always be ready for a case in rebuttal in anticipation that the defense is going to rest. Okay. Sometimes you can judge from how things are going. The court will call you up and say, hey there, Mr. Reich, how many witnesses do you think you're going to have? We may have one, maybe one. Okay. So we'll be ready to go. And you tell the court, but you're under no obligation to do so. But for the judge to sit there and say, oh, you don't like my rulings. Oh, really, Judge? Because I'm supposed to sit here and smile every time you make a terrible ruling against my client. The defense attorney in this case, she filed a motion to recuse the judge. And as soon as I saw that the motion to recuse was filed, save your breath. I hope they didn't spend too much time on that. It will be denied. Short of a life without parole sentence, this will be appealed to a higher court. Is that enough to result in an unfair trial that the judge, as a defense attorney, sometimes you just get used to the judge ruling against you, because your motions issues, you may think, oh man, this is a great motion to suppress. We should win this thing 10 times over. But if you have a crappy judge who, frankly, maybe he's not that smart, not that well-versed on the law, always does what the prosecutors want to do anyway, your motions issue is only as good as the judge that it's in front of. If you have an intellectually honest judge who sits there and says, yeah, the police screwed up, motion to suppress granted, boom, you're golden, right? But it's only as good as the judge that you're in front of. I've seen a lot worse. I've had a lot worse in front of a jury. Okay. And frankly, I think it works wonderfully. It works to the benefit of the defense. Okay. Because if the judge is relaying to the world that they don't like you, sometimes that helps. Let me give you an example. Okay. Years ago, I had this trial. It was a simple little trial. It was a drug case. The defense wasn't my guy. It wasn't my guy. We even had another guy that came in under oath and said, I understand I have Fifth Amendment issues, but I'm going to testify because I can't let an innocent man go to prison because they were my drugs. I was the one out there selling the drugs. This is my hoodie. This is, it was great. Great. The judge hated my client, and the judge, by the end of the trial, hated me. And so it was a pretty hard-fought battle for sure in this trial. They tried to keep our witness off the stand. The confidential informant that came in to testify that my client was the person that purchased the drugs, let's just say he had a checkered past, okay? He had a list of felony convictions for drug offenses a mile long. He had a bunch of other misdemeanors involving crimes of moral turpitude that are ripe for cross-examination. Okay. And so I had them all ready to go. I had all these misdemeanors. It was like shoplifting stuff, right? But if you're going to shoplift, you petty little thief, why should we trust you in matters of great importance of this trial, right? So we're there, and I'm cross-examining, and isn't it true you pled guilty to this? Boom, boom. And the prosecutor finally object. And the judge, I thought was going to jump over the bench at one point, is like, Mr. Reich, enough, sustained. And he points to me and he says, the jury will disregard Mr. Reich's statements. He is trying to besmirch this man's character. And I think I looked at the jury and I said, yes, I am. And the judge didn't, it was smart ass of me. It was sarcastic. I shouldn't have done it, but the judge was just being such a jerk to me. Right. And so we go back, the jury deliberates. We rest, the jury goes back and deliberates. And I remember it was cold because it got dark really early, and the jury came back, and it was, late. It was probably after 5 o'clock, which, they used to be able to do, but now with budgets, they can't do that. No one can work late anymore. So whatever. And as we're sitting there, and, they come back, they read the verdict, and I could see the judge is literally gritting his teeth as he's reading the words not guilty like 2 or 3 times. And my client's there, and a couple of the jurors walk by on their way out of the courtroom before the judge, does something, says his final words to us. And one of the ladies walks up behind him and says, we weren't going to let him get you. Referring to either the prosecution or the judge. The judge was the one that I think helped my client, because he came across as so biased that he clearly wasn't being fair and impartial, right? That's what a judge is supposed to do, call balls and strikes, not have some skin in the game, so to speak. And he clearly had skin in the game, hated my client, just wanted to throw him off to prison. And, and that was it. And, always brings me, great pleasure when they don't like your client and they said, all right, let the judgment of acquittal enter. And, oh, Your Honor, excuse me. Can we get a bond release, please? Because, he's not going to prison tomorrow. Like, just screw you, judge. Like, why do you have to be a jerk? But that's the way they get sometimes. Not all judges. There's some really great judges out there that give you a fair trial. And if you're going to lose, if you lose, they're going to launch your client. So this did not take place in front of the jury, thank goodness. Then perhaps it could have been a situation whereby, it could be prejudice, seen on appeal as prejudicial. Now, if the judge's rulings, and don't get me wrong, what can you expect? I've had clients that have got upset over the years. Like, man, the judge denied every motion we filed, denied, sustained every, or overruled every objection you made in trial, Scott. Like, man, this judge she's biased against you. I'm like, well, we've got some bad facts. The law is really not on our side. But guess what? At the end of the day, we still ultimately won. Okay. You can't make any promises or guarantees, but I've literally won trials where they've denied every motion that I've ever filed, overruled every objection I ever make, and we still win. Okay. And just like the little example I gave, when the judges start, it just looks like they're just being not fair. The juries pick up on that. And let's face it, most people kind of sway to the underdog unless the judges are doing their job, giving both sides a fair trial. But if it comes across that they're not being fair to everybody, that's it. And if a judge can't deal with, somebody taking off their headphones or, whatever, part of that is respect for the judge, right? If you have respect for a judge, I always call the judges I respect, yes, Your Honor, no, Your Honor. If it's a judge I don't particularly respect, yes, Judge. Yes, Judge. sometimes that's on the judge as well. Sometimes you have to, sometimes you have to reflect upon yourself and say, hey, maybe it's me, right? Maybe the judge has to do that a little bit as well. So we'll just have to wait and see. Needless to say, the judge denied Mr. Cruz's motion to dismiss, and even though she said it was the most unprofessional thing she'd ever seen, it's just one of those deals where you have to kind of get over it. There's judges you like, there's judges you don't, there's judges that hold your feet to the fire. It is what it is. It's called the practice of law. But when you do it and all of a sudden it doesn't exactly instill trust and confidence in your client, where the client starts questioning, I don't think she's going to give me a fair trial. What is there to say? It's a question of fact for the jury to decide. Does he live or does he not? It's not up to the judge. So her decisions will be subject to appellate review, assuming he gets the death penalty. We'll have to wait and see. But the defense rested after they had 44 witnesses left to go. That's what the prosecution was complaining about, was that they had 44 witnesses to go. We weren't prepared to do this. Okay, move it up. Instead of saying, we'll come back in 2 weeks, why don't Mr. Prosecutor, get your witnesses here. Do what you got to do. I'm pretty sure, right, the jury has seen the evidence that's come in for aggravation. They've seen the crime scene, which they would have, they would be able to see to make their determination. The defense's theory was simple, that he was basically, Nikolas Cruz was an abused kid by his mother who used drugs and you name it, and basically never had a chance in any way whatsoever. I'm sure the jury's probably made up their mind one way or the other. Another 44 witnesses aren't going to do it. And in a case in rebuttal, how many witnesses could you possibly have as the prosecution to come in and say, oh, we're going to do that? Anyway, let's move along here. Anyway, it's like one of those things, just practice of law. Listen, you better have some thick skin, whether you're going to be a prosecutor, defense attorney, or a judge. And, to write a 22-page motion to disqualify certainly is good for the record, probably felt really good venting, but it's probably time you could have probably spent on other things like preparing your closing statement. You made your record, filed the motion, I guess, but do you really think the judge is going to recuse herself when we're this close to being done in a death penalty case where we have to start all over again? Just don't see that happening for sure. Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked. All right, next, Eliza Fletcher, okay? Eliza Fletcher would probably be alive today if the police had acted on a previous sex assault case. Well, guess what? That woman is now suing the city. So a Tennessee woman says that in 2021, she was sexually assaulted by the man who would later be charged with kidnapping and killing Eliza Fletcher, and she is now suing the city of Memphis over what she describes as its negligent failure to investigate the attack. In a lawsuit filed Tuesday, Alicia Franklin says that Cleotha Abston raped her back in 2021, less than 1 year before the alleged kidnapped Fletcher, in the early morning hours of September 2 of 2022. Now, Ms. Fletcher was out on a morning run near the University of Memphis when Abstin allegedly ran up to her and forced her into an SUV. Her body was found days later. Now, Franklin, who has discussed the case in several interviews, said that in 2021, she had communicated with a man named Cleo for about a month through text messages and a dating app. Franklin says they met in person on September 21st at the Lakes at the Ridgeway apartment complex, where Cleo said he was a maintenance man for what was supposed to be their first date. Now, according to the complaint, Cleo was actually Abstin, and he also allegedly went by the name of Cleotha Henderson. They allegedly had plans to go out for dinner, but Cleo drew a gun on her instead. According to Ms. Franklin's lawsuit, he allegedly forced her into a vacant apartment where he blindfolded her with a t-shirt and threatened to kill her. He walked her through the apartment, according to the complaint, and outside the back of the apartments to his car, a white Dodge Charger, where he forced her into the back seat and raped her, according to the complaint. Attempting to talk him out of it, Franklin said that she was pregnant. Cleo was unmoved by her plea and responded with words, "All you bitches say that," or substantially similar words, indicated that he had likely raped other women, according to the complaint. Now, after the attack, Abstin allegedly forced Franklin back into the apartment at gunpoint and ordered her not to leave until she heard his car engine revving. He was charged with obviously sexually assaulting Franklin almost a year after allegedly attacking her, and authorities said a DNA match in the 2021 rape case finally returned a match on September 5th of 2022, the same day Fletcher's body was found in South Memphis. Franklin says that police did far too little to investigate her 2021 case. In her complaint, she said she took a rape kit after the incident. Police took her back to the scene of the crime, but they took no physical evidence directly from the scene itself. She also says that she gave police information such as the name Abstin allegedly provided, Cleo, his phone number, a description of his vehicle, and social media information, including the dating app. She also told them about the pregnancy comment. Authorities already had access to Abstin's DNA from his 2001 guilty plea for kidnapping and robbing an attorney within hours or days. Police gave Franklin a visual lineup that included Abstin. The complaint asserted that police already had the evidence they needed to arrest him for the sexual assault and that they should have been well aware of his criminal history dating back to age 11, which included an alleged sexual assault. Now, Ms. Franklin was not able to identify her attacker based upon the photographs that she was shown at the time in the lineup, according to the lawsuit. Ms. Franklin overheard the police say something to the effect of, maybe we should show her a more recent picture. This photo was probably when he was 12 years old. But police either failed to get the picture or they failed to tell her, according to the lawsuit. And according to the complaint, authorities had access to more current photographs from Abstin's time in the Tennessee prison system, and he had been released from prison on the kidnapping and aggravated robbery charge back in November of 2020. Now, officers also allegedly failed to ask the Tennessee Bureau of Investigation to do a rush review of the suspect's DNA in Franklin's case. And by comparison, Franklin's lawsuit said officers in the Fletcher case submitted a sandal or a DNA information from a sandal to the Tennessee Bureau of Investigation requesting an expedited analysis. And in just hours or a few days, the TBI, the Tennessee Bureau of Investigation, replied that the DNA on the sandal matched Abstin. Essentially, Franklin's complaint alleges police had all the evidence that they needed to stop Abstin from allegedly striking again. He was also already on their radar. They knew he had a lengthy record, and they should have known he was a continuing danger to Franklin and the community. They state in this complaint, Cleo Abstin should and could have been arrested and indicted for the aggravated rape of Alicia Franklin many months earlier, most likely in the year 2021, based upon all the information set forth in the preceding complaint paragraphs, and the abduction and murder of Eliza Fletcher would not have occurred, according to the complaint. That seems pretty reasonable. For now, local law enforcement obviously is not talking at all, but they allege, obviously, that Cleo Abstin should and could have been arrested and indicted months earlier. So you have to wonder, gee, when they have a sexual assault kit, Why did they not do a rush DNA and put it through the CODIS system, which stands for the Combined DNA Index System, which basically anyone, if you have a criminal history, is in there. Now, the complaint alleges, because remember, in any sort of civil complaint, you have to show that there is a duty by somebody involved, that they breached that duty, and but for the failure of that duty and the causation, that there are in fact damages. Here, the complaint alleges that the city of Memphis was required by the law of the state of Tennessee to perform an audit of its sexual assault kits and an audit in the year 2014 to determine that the city of Memphis had more than 12,000, get that, 12,000 sexual assault kits in its possession, including more than 6,000 sexual assault kits that had not been submitted for testing. Now, since the Tennessee Bureau of Investigation rarely knows the facts of the case relating to each sexual assault kit submitted to the TBI, then TBI relies upon the submitted agencies, including the Memphis Police Department and the city of Memphis, to identify cases that would benefit from investigation on a rush basis. Tennessee law, according to the complaint, alleges that there is a duty imposed upon police officers to investigate crimes reported to them, and Tennessee law imposes or should be construed to impose a heightened duty to investigate violent felonies like rape committed against victims with a deadly weapon thoroughly by utilizing available evidence on a timely and expedited basis. And the complaint alleges that they breached that duty, in this case, directly and approximately caused harm, which would not have otherwise occurred. Now, because the sexual assault kit from Alicia Franklin's sexual assault was not sent to TBI with a rush request or a request to it be processed on the expedited basis, no CODIS hit or match was obtained for Cleotha Abston until months after the alleged rape, and there are numerous private forensic laboratories that are certified to do DNA testing for municipalities for a fee, and these laboratories were available back in September of 2021 to process the plaintiff's sexual assault kit. And knowing that it would likely take several months, if not years, to get the results back from the Tennessee Bureau of Investigation without a request for an expedited processing. Yes, ladies and gentlemen. Wow. And I understand where the victim is coming from in this case. Miss Franklin, she wants justice. Nothing was done. The police, they sent it off where literally, I'm telling you, here where I practice law, it takes a trial setting for DNA evidence to get tested unless they are doing a match early on and there is a request for it. DNA testing is expensive. It's not something you just go and you do. It takes, on a rush basis, still several days to do the extraction, the testing, the analysis of the interpretation of all the DNA numbers that come out. So I get their frustration. I get Miss Franklin's frustration in this particular case, but I think, unfortunately, this case was probably going to get kicked out of court. Why, you say, Scott? Let me tell you why. It's called sovereign immunity, right? You can't sue the king unless the king gives you permission to do so. Now, it's very vague in the complaint when I read it. It doesn't necessarily identify how they intend to get around sovereign immunity in this particular case. But it is clearly a statement saying, hey, police agencies, not only in Tennessee, but in other jurisdictions, you better get your act together because one of these cases could stick. And what I mean by stick is it could go forward and suddenly the city winds up paying lots and lots of money and there could be civil liability for the police officers. Now, do the police officers, could they have rushed it? Probably, but they're probably given marching orders that saying, hey, this is an expensive process to do. Who knows what the cops were thinking, but they didn't rush it. And it wasn't until Miss Fletcher, apparently, the heiress of a billion-dollar fortune, that they were actually able to expedite something. I mean, I don't want to necessarily say it depends on who you are, but sometimes it depends on who you are. What do they say? Everybody's equal, but some are more equal than others. Just saying. Anyway, obviously the Fletcher case is tragic. I agree she'd probably be here if the police had done it. They dropped the ball, but I'm not sure the case is going to go forward. Now, we could have a huge discussion another day about the whole social contract theory, of society and what the role of the government should be and what we give up when we say, hey, protect us. But we're not going there today, all right? So a few thoughts on the Lori Vallow matter. I went back through several of the items on the docket in this particular case. And something that I thought was interesting was that the attorneys for Lori Vallow made a specific request for discovery in regards to any statements made by co-defendants, prosecution witness, or prosecution witnesses to the prosecuting attorney or to the prosecutor's agents, okay? And they stated, upon information and belief, the defendant has reason to believe that many of the witnesses and prospective witnesses living in Arizona, Utah, Texas, and elsewhere have been having regular contact with the prosecution and or agents thereof. None of these witness statements have been disclosed. The defense is concerned about ongoing issues of discovery violations. And there was another couple of requests, but it really meant nothing. But the government's response, I was going through, and I thought this was interesting. And in regards to that first request, the prosecution stated the state has no objection to the substance of this request, but objects to the assertion that the state has not complied with the requirements under the Idaho Criminal Rule 16. That's the rule for discovery. Prosecution has to give you everything that they have. The state has complied with this request and will continue to comply. And then they go on and state some typical stuff that you always see in these kinds of responses, which is the prosecutor doesn't have a duty to collect evidence, nor is there a constitutional requirement that the prosecution make a complete and detailed accounting to the defense of all police investigatory work on the case. Obviously, it'll be memorialized in a statement. The prosecutor is not required to deliver his entire file to defense. I agree, not all of it, but pretty much close to it. And then it says the defense asserts that many of the witnesses and prospective witnesses living in Arizona, Utah, and Texas, and elsewhere have been having regular contact with the prosecution and their witnesses. Where the defense has not provided any specific allegations to support this assertion, the state is unaware of what contact the defense is referring to. Any statement made to law enforcement by witnesses are provided in reports, and discovery will continue. Any statements that are discoverable will be provided on their ongoing Rule 16 obligation, standard response. But then something interesting. It says the Idaho Constitution, Article 1, Section 22, subsection 5, provides the victims of crime the right to communicate with the prosecution. A similar right is found in Idaho Code, specifically Section 19-5306, subsection F. The state is unaware of any authority that requires the state to notify the defense of every communication it has with a victim or witness. Further, the state is unaware of any authority that construes the meaning of the word statement so broadly as to include every question or concern raised by a victim or witness to the state. Such an interpretation is inconsistent with the law and with realities of litigation. So it makes me think that there's some sort of jousting going on here, that the defense feels as though, say, for example, there's nothing that says that the prosecution, every time they notify the victims in this case, for example, the Woodcocks, of an upcoming event, of an issue, that does not necessarily constitute a statement. I would agree with that. I can attest to this, that after every court appearance, if there's a victim identified in the case, they get notice of what took place and when the next court date is, and if they choose to be there, they can do that. Sometimes victim advocates notify the victims and witnesses personally. Sometimes they put it in a letter. Those communications, though, are usually strictly prohibited to be turned over to the defense. Frankly, I've seen litigation to try to get those communications, and there's little to no luck in achieving that whatsoever. So I'm not sure what kind of fishing expedition the defense is going on there, but there seems to be something to the effect that they're trying to get all communications between the district attorney's office and witnesses. Normal victim-witness communications doesn't cut it. But I thought that the response from the district attorney was interesting, since they really didn't go into specifically the witness communications, but they said, hey, even if we did have communications, basically we're not entitled to turn that over under the law. And I think the prosecution is correct in that response. So just something to think about. I think the defense is finally realizing, hey, we have 140 witnesses to prepare for at trial. How do we know we have everything? Let's shoot a request over to the prosecution. Maybe they'll do a little bit of work for us. Now, I think that Lori Vallow's attorneys seem very ethical. They seem very experienced in litigation, and I think they'll do a fine job representing her to make sure that they hold the government to their burden of proof. And the prosecution should say, we gladly accept that burden, we embrace it, and we're going to prove the case beyond a reasonable doubt. We'll see. Hopefully things are going to heat up, because guess what? In just a few short weeks, we're going to have the hearing with Lori Hellis on October 13th in regards to trying to get access to all these sealed dockets and filings and hearings in this particular case. And that's what I'm waiting for, ladies and gentlemen. Unless, of course, the judge denies it. Like I think he's probably going to say no cameras in the courtroom. But we'll wait and see.